We are live. Good evening, everyone. Welcome to another episode by LawSikho. And today webinar is going to be different because in today's webinar we are going to discuss about the three new criminal laws that are recently introduced by the Parliament. And in this webinar we are mostly discussing about the Bharatiya Suraksha Sanhita Act, which will replace the Code of Criminal Procedure. So, to address, to guide us about to do the discussion about these three criminal laws, we have guest speaker with us. We have Mr. Vaibhav Chaudhary with us. He is advocate on record in the Supreme Court of India, practicing advocate in the Supreme Court of India, and also an expert in the subject matter. So, thank you, sir. Thank you for joining us.
Thank you, Ina. Thank you for inviting me again, and good evening to everyone.
Thank you, sir. So, sir, let's start our discussion or one-on-one discussion about the act that will going to replace Code of Criminal Procedure and how it will going to do that. What changes will it bring to the society? So let's start our discussion.
Thank you, Ina. First of all, I think I would like to tell our viewer that how this acts will be implemented. Because on 25th of December 2023, the President has given her assent to all three new criminal law, which is Bharatiya Nyaya Sanhita first, which is replacing IPC, then Bharatiya Sakshi Sanhita, which will replace Indian Evidence Act, and then the Bharatiya Nagrik Suraksha Sanhita. The criminal procedure code will be replaced by that. On 25th December, the notification came. However, in the notification, it is also mentioned that section-wise implementation will be notified at the later stage. Earlier, there was a concern that it might be notified post 26 January 2024 onwards. However, there is no such notification till now. Now the information is coming from the Home Ministry that they are working to implement all this act first in some union territories, and the pilot project is already going on in Union Territory of Chandigarh, and they are also planning to implement first in the state of Gujarat as well. So there was a meeting held by the Home Minister last month in December with all the LGs of the union territories, and they are building the infrastructure because, as you aware and everybody is aware, there are so many things which is now required to be done before they are actually implemented. There's a police training required, judicial training for the magistrate level is required, and the Judicial Academy of Bhopal, and there are 2-3 main organizations who are working for this implementation. So I would like to inform everybody that one is the National Crime Record Bureau, and the other one is the Bureau of Police Research and Development, and the CAPT from Madhya Pradesh Central Administrative Police Training Program. These are the three main organizations who has been given the responsibility to implement, to train police officers, judicial officers, and all the concerned. And there is also information appearing that the Home Ministry or the Home Secretary has written letter to the registrars of all the high courts as well as the Secretary General of the Supreme Court of India to take appropriate and necessary action from their side, whatever is required to be built up in the judicial infrastructure side. Because as you are aware that the respective high courts are also responsible for the law curriculum development also in the national law universities. So they are suggested that the same thing can also be done before the implementation, and from the next academic year onwards, the students or the law students should be taught the new provisions of the criminal law, IPC, and the Evidence Act. So all this thing, and this interesting thing, one of the interesting aspect which the government is currently working, that because now under the CRPC there are so many amendments and it's forensic driven investigation will be there. So they have preparing a forensic science laboratory vans which will be there in every district. So they are planning to deploy around 900 forensic science laboratory vans in each district. So as and when there is any crime for which a forensic investigation is required, so that will be equipped with all the material which is required and proper investigation can take place. Because if you remember that there are some famous cases where the High Court and the Supreme Court has come heavily on the local police who was at the site at the instance, that they have not properly investigated and the evidence collection was not proper For that purpose, there are new provision under this provision, and for this purpose, there are specific forensic science laboratory vans are now been under the guidance of Home Ministry has been prepared, and there is a pilot project is also going on. Now, with regard to the implementation aspect, that now it will come, the date per se has not been notified, but it is planning that they will introduce in December 2024 in the union territories, and thereafter they will be implementing in the remaining state. But this is one of the concern by the legal fraternity per se, that it is impossible that simultaneously we can have two type of set of criminal laws, the earlier act and the new criminal law. Just hypothetically examine that in one of the state you will be governed by IPC, and in the union territory you will be governed by Bharatiya Nyaya Sanhita. So this matter has also reached Supreme Court and Delhi High Court. Per se, there is no stay. They have not adjudicated on this issue yet. But if they are actually implemented phase wise, so there might be some concern. And there is also issue whether there will be some retrospective effect. Although there is no provision per se, so the pending trials is supposed to be governed by the earlier law as per the criminal law system. There cannot be a retrospective effect to any criminal law. So that is also one of the concern with the lawyers, that how ultimately whether they are going to give any retrospective effect to any provision in these three criminal laws. Now,
Even
if we
I
come
want
now
to,
to the yes,
even I, sir, if you could explain the retrospective aspect, how it will gonna impact the trial
pending trials
cases,
and everything.
pending trial cases.
So I think in a per se there is no provision to have a retrospective impact currently, but there is a concern and there is a discussion and there is a such concern, there is a possibilities that might be introduced through some notification at the later stage, which is highly improper for the government to do so, because they are just judgment from the Supreme Court and high courts also, that criminal law cannot be a retrospective effect. And even in the pending trial, when at the time of the commission of the crime, it is supposed to be governed by at the law which was prevailing at that time. So there is highly impossibility that there will be any retrospective effect. But let's see once they are actually implemented, because the government is planning to have to take 1 year time period to implement this law. So the another issue or concern was raised, if the government was not prepared to implement these laws when they were notified, so what was that hurry to introduce in the parliament and get that standing committee report in such hurry? The people have not participated. There was no discussion. Even the report which was prepared by the criminal law reform committee headed by NLU vice chancellor, there was no discussion per se, and it is not made available to public. There was so much criticism about that constitution of that committee also at that time, and matter was reached to court also, there is no female representation, other gender sections were not represented per se, there was no representation of the various societies representative. But now the report has been prepared and they have prepared this bill. The bill was reintroduced and now they have been notified but not implemented. So now I think we can move on. What are the major changes under this? I can give just brief background. First,
Also,
regarding the Bharatiya Nyaya
also,
Sanhita.
yeah, I
Yes,
also I feel that will there be change like in section numbers only, or there will be actually a change? For example, there
yes,
was a change in Company Act also, but there was only change in sections. So, is it something like that or something different?
yes. There is a change of sections. The chronology has been changed. The number of sections has been changed. So I just give you a brief overview about this. Under the old Indian Evidence Act, there was 167 sections, and now under the new Bharatiya Sakshya Adhiniyam, there are 170 sections. So there are some sections has been added, deleted, and there has been rearrangement also. And now with regard to IPC, there were 511 section earlier. Now it has been short down to 358 only. So number of section, which was per se the definition part from section 2 to 50, which was earlier in the IPC because there was separate section to define. Now all this has been clubbed under section 2 only in the definition aspect. So there is a reduction of sections in Bharatiya Nyaya Sanhita from 511 to 358. In CRPC, earlier we have 484 section, and now it has been increased to 531 sections. So, and there is a rearrangement also. The chapter wise rearrangement has also been made, majorly in the IPC. Now, earlier, the murder was 302, the FIR registration was 154, sedition was 124A. All this has been rearranged. So, we have to remember and mug all this up as per the new laws, as and when they are implemented. So,
That's
I
why
can
there are
now
so
move
many
on.
reels going on that judiciary aspirant must be very, stressed because of the realignment of the sections and all.
Yes. Because the thing is, they wanted to have that the colonial mindset should go. There was some reference to earlier British related some terms has been removed. Per se, entire exercise is just a rearrangement of section. There is no per se drastic changes in any of these existing laws. They have
Oh,
added few definition, deleted few definition, added few crimes. Some new things has been added. Electronic communication and use of electronic communication has been added, which is good. There is a time bound trial and all this thing has been added, which we'll discuss in detail. But overall, just to give an idea to our viewers also, first with regard to the IPC, few changes I just would like to mention. uh, the offense of mob lynching per se was not there as per the existing IPC. Now we have an offense with regard to mob lynching. So new offense has been added in the Bharatiya Nyaya Sanhita. Now we have some new definition of terrorism, abetment, harboring, and conspiracies, and all these things. The interesting aspect which has been added now, which was required also because that is an existing concept in the other jurisdiction, which is community service as a punishment. So there will be certain petty offenses under which instead of sentencing them for imprisonment or imposing fine, now there will be community service. The community service term has been defined, but what will fall under the community service will depend how the court is would like to interpret. Earlier, if you remember, there were numerous occasions where some courts, district court or high courts, tried to give these types of community service. Please go clean this river, do some traffic violation duty or something of that sort, which used to be set aside by the higher court because it was not recognized under the Indian law. Now there is an official section under new Bharatiya Nyaya Sanhita that there will be community service, which is a good thing because some petty crime there is no need to increase the prisoners in the just for 1 month, 2 month, 3 month imprisonment and all this thing. So you can have community service, but while doing that community service, you will not get any remuneration. If you are sentenced to do some service for 1 month, whatever you do, you will not get or entitled to any remuneration. That has also been mentioned in the IPC, in the new IPC. Then there is too much discussion that sedition term, if you are aware that 124A IPC has now been removed. That term per se has been removed, but the same definition now has been under still there under the new Bharatiya Nyaya Sanhita. I think these are the major changes, and there are reorganization of sentences sections. Some punishment has been increased with regard to few sections, and the terrorism term has been defined, and there is an increase of sentence in 41 offenses, and there is a decrease of sentence also in few petty offenses. These are the major thing with regard to the IPC. But now we'll come to the main aspect which we would like to discuss is Bharatiya Nagrik Suraksha Sanhita, which is basically the CRPC. So the title itself is also controversial that why the government has decided to have a Hindi title or Sanskrit title, because usually it is always a English universally accepted term, IPC, CRPC and all this thing. But now the major changes which will be there in the CRPC, which now will be recognized as BNSS. In short, earlier we used to refer CRPC for our convenience. Now we have to refer BNSS of 2023. So first major change, which is a good change, a positive change, it is the timeline has been fixed to deliver the verdicts once the court reserved the judgments, and the time sheet has also been defined with regard to filing of charge sheet and so many other things. So that time period has been defined. Once the court reserve, the session court or the trial court reserve the judgment, it has to be pronounced within 30 days, which can be extended for further 30 days, but subject to the region has to be recorded. in the judgment itself that why there is a delay. This is a very welcome step, because if you just imagine that we are getting trial court judgment within 30 days with regard to some murder cases or whatever, usually currently, because the trial court judges are overburdened, even if they want to deliver, they can't to do so because of administrative difficulties and the number of judgments they have to write or pending and whatever issues. So this is now the burden has been created on the district level magistrates that they have to deliver judgment within that time frame. So this is a welcome step with regard to the trials. Another
In
thing
all
is
cases, in all cases, even like
in all trial
offenses.
cases,
Oh,
wherever there is a judgment reserved, it is not necessary always that the court has to reserve the judgment and then, but now they can dictate in open court also at that time only, subject to the judge's discretion. Because if the lengthy trial is going on, there are so many witnesses, evidence, so they need time to prepare all these things. So this is how the court practice that they reserve the judgment and then they pronounce. For
but it's
that
a very
purpose,
drastic step. It's a very
yes, yes,
drastic step. From taking 10 years to take only 30 days. Isn't it a big deal?
30
It is
plus 30, total 60 days maximum.
okay.
Yes. This is a very welcome step. It is already there in the other jurisdiction. We never had this because the infrastructure issue was always there. So it is
Hmm.
creating, we can also say it is creating a negative obligation on the trial judge also, that that he has to declare, so that quality might be compromised. That one of the concern has been raised of the judgment per se, that he or she would not get that proper time to read and everything. So simultaneously, usually now they have to work on while hearing the witnesses and everything. Other major change is there is a provision with regard to zero FIR. If you know the concept of zero FIR, the zero FIR is if the crime has been committed in particular locality and the person concerned, instead of that jurisdictional police station, going to some other police station and trying to register an FIR. So per se, there was Supreme Court judgment on this issue. So it was used to be applied. Now the provision has been officially added. I can register the FIR wherever I am at that time. That concerned police station has the burden to transfer immediately to the competent jurisdiction within 24 hours. So this is one
But
of the
sir,
major welcome. Yes,
yeah, but this provision, the zero FIR provision, was always there in the CRPC. But right now it has been
there is a time frame
highlighted.
also.
Yeah.
It was not per se that term was not there, and now there is a specific provision which will define the term has also been defined, and within 24 hours you have to transfer that FIR to the competent jurisdiction. The burden has been cast to the concerned police station where the person has registered the FIR. There is a judgment also on this issue. Police are registering zero FIRs nowadays. Earlier they used to refuse, because if you remember in the Nirbhaya case also, there was a huge fight between two jurisdictions of the two different parts that this will fall under which category. So there, that was a concern which was raised in the Nirbhaya rape case also, that why the police has taken too much time to register the FIR at that time. So that is another the welcome step with regard to the zero FIR. And that another concern is that handcuffing thing. Whenever police arrest somebody, they used to handcuff that person while at the time of arrest also, and while taking that person to the court also. So there are number of judgment by Supreme Court and various high court that for all the offense this is not required, because this is affecting the reputation of that individual. He might not be declared guilty at the later stage, but handcuffing at the public place, it will affect his reputation and might be violative of Article 21 and all this thing. But now the change has been made. Some offense has been defined under which this will be allowed, and economic offenses has been excluded from this. It will not apply for the economic offense. Was based on the recommendation by the standing committee, because in the first draft which was introduced in the August, all the offenses were there. Then there's a criticism and all these things. The standing committee of the parliament, they have made this recommendation which has been accepted. So now it has been restricted to few offenses only. Now, with regard to the Evidence Act, the major changes is the admissibility of the electronic evidence. Now, the electronic evidence will be admissible, and who can authorize, who cannot authorize. There is a detailed provision and procedure has been set out where there was some ambiguity earlier. And the another major change is the acceptance of proceedings through audio-visual means. Proceedings can be conducted through electronic means also, like this types of meeting, whatever software the high courts or district courts are using, they can have. The summons will be issued electronically, charge sheet can be filed electronically, it has to be shared with the victim, the complainant within the time frame, and the evidence can be recorded electronically. The and once the evidence has been recorded by witness or whosoever, his signature has to be obtained within 72 hours. All these provisions has now been made. So the one of the major development which will impact this entire criminal justice system will be the use of the digitalization basically of the court system and the entire criminal system. So if you want, I can just refer few specific things with regard to this, that the provision and all this thing, just like that, someone can now be served digitally under section 64, section 62, and section 70. The issue process can also be done electronically. Notice tendered by the executive magistrate, warrant, all can be served through electronic means. Police report, other investigation related document under section 173 and 207 can be digitally shared under new section of 193(8) per se. And then the order of confirmation of death sentence under section 412 of BNSS can also be done through electronic means. Reading out of charges is also allowed to the accused, that there is no need to bring the accused at the court. The charges can be read out in, if wherever he is lodged, in whichever jail, through electronic means, which is acceptable. The statutory provision has been made now. Earlier there has to be specific application, we have to request and all these things. Now the provisions are there, the trial court is bound to follow all these things. Then there are so many other things also with regard to which the electronic channels can be used. And in the interesting aspect will be that the jurisdiction in case of electronic communication, I am communicating through email, whatever, WhatsApp, or whatever. In case of offense of cheating has been conducted through any electronic communication, the sender or the receiver can have a right to raise the complaint in their respective jurisdiction. This has already been mentioned now. So that conflict which is about to arise once it was implemented, that which is the competent court with regard to this, has already been settled. Sender and receiver both has the right that they can file complaint whosoever has been cheated in their respective area wherever they are residing. That district court has the competent jurisdiction.
This was
Now
all
the
also this was there in CRPC also, like in section 182. I think it was there. Like same the digitalization. Yes, it is a change, but I think more and more sections are kind of same only.
Yeah, there is no
Uh,
major change per se. That
there's no
that is
major
absolutely
change per
correct. That
se.
is the major criticism also. That there was no need to rename the entire thing. You have just rearranged few sections. You have added few sections, very limited sections in all three acts, and few things here and there. These types of amendment. For that, the entire criminal law was not required to be changed. You could have
But
made
yeah,
amendments only.
digitalization will really bring the change, so that it's actually relief to the accused person also. He or
Yes.
she have not no need to come to hearing every month, and hire an advocate, then give money to the advocate. They can appear online also, so it's a big relief to the
That's why the Home Ministry is
yeah.
saying that we are taking 1 year time period. So the entire infrastructure is set out. And once these laws are implemented, so there should not be any issue that this court is not ready, this state is not ready, there is an infrastructure issue, they cannot send someone through electronic means, they are connecting all police stations. Every police station are also be trained by the Central Police Training Association, that these are the things which you have to do now, because you know that there's a major objection and obstacle, we can say, by the police people also, that the old police people are not ready to accept all these changes because they are not computer savvy, they are not that tech savvy advanced. So the new generation in the police officers, they has been trained specifically so they can guide, and this training is ongoing. At the time we are speaking, this training is ongoing in the different part of the country by the central tribunal, the central training center, and the NBCC and all these things. So the all
Supreme
these
Court
changes are
also
quite.
giving training. Is Supreme Court also giving training to advocates on
Supreme
record or?
Court is not giving per se, because you know this nothing is coming to Supreme Court directly. Whatever changes has been made in CRPC, IPC, there is nothing which is about to come to Supreme Court directly. Other than that, we challenge some constitutional validity of these provisions later on because of the whatever reason. Those types of writ petition will be there, but nothing. Everything has to come from district court to high court and the Supreme Court. There are very few instances that this provision can directly be invoked in the Supreme Court. Very rare. But Supreme Court is involved. That E committee of the Supreme Court is the overall looking authority who is guiding, and under which the Home Ministries are also taking instructions, because that judicial infrastructure that need to be developed. For that, E committee has already been made responsible, which is under the guidance of the Chief Justice of India. That whosoever is the Chief Justice of India, he is the head of that E committee. So that judicial infrastructure development with regard to these, and otherwise also they are developing this judicial infrastructure with regard to that VC hearing is now kind of been made permanent. So now once this law is implemented, so the trial courts will has to have compulsory VC hearing. Lawyers will appear through VC, the accused will appear, the complainant, the victim, everybody can appear through VC hearing, and their statement will be recorded, and all this, whatever the provision has been made, everything will be through VC. So that judicial infrastructure purpose, Supreme Court is involved, that E committee, and that E committee is anyway consists of all the high courts, representative, and all these things. So that overall hierarchy in the body is the Supreme Court E committee, and there is no training for us, as you were asking for AORs, because nothing per se is required from our side to be trained on this issue, other than because we practice in high courts and district courts also. So that judicial academy training might be introduced for lawyers also, that bar council and the bar association might be asked if required. There is a letter and all this thing is, but currently there is no per se training for the advocates from high court or district court. But there is some training, I think I suggest that it might be required even from advocate perspective also, because we are the one who are going to bring, because judges will have to implement, we have to raise this issue, and police has to follow the procedure. So all three, if there is a training for police officials also, there has to be some training, at least for the lawyers who are practicing in before various district courts. What are the changes, and what are the changes, sections will be changed, so many things will be changed. Let's see
Also,
that will happen
sir,
or not.
yeah. Also, I request you to guide us on the new section that has been introduced on 10 years. It has 10 year of imprisonment. Uh, so that if they are living relationship, the both couple, husband or living partner have made a promise that he will marry and this and that. It have a 10 years of imprisonment. So what impact it will this section will bring to the society, and will, because already there've been many false cases filed. So so I out of curiosity I feel that we should also talk about this
Yes,
section.
yes. Offenses against women. Now there is
Yeah.
a entire chapter with regard to. There was always a chapter, but there was some haphazard and all this thing. But now there is a complete chapter with regard to the offenses against women, offenses against child. This is specific issue that based on false promise of marriage, the women are victimized, they are raped or whatever that, and then this offense has now been made official, that if somebody is made false promise, or they impersonate somebody or misrepresent that I am this and that, so these types of offense has been added. There's a strict punishment for that, 7 to 10 years, and above that also. For rape, the definition of rape is same, but and no new punishment has been added, because there is already the strict punishment under the CRPC. Same has been retained, that life, gang rape, there we know that there's a life imprisonment also in context of gang rape because of the earlier criminal law amendment, that has been retained. That false promise to get married and all these things, these are few new additions, and strict punishment has been per se introduced in the new law. So that is always required, which is a good and welcome step. Everybody is welcoming this. And I think there are some concerns also. If I think if you would like to discuss that, the police accountability, there has to be police accountability, because these are the first responders. Whenever there is a crime or whatever occurred, people inform the police and they have to respond. That police has been given too much of power now. Again, their power has been increased, and there is no accountability per se for the police personnel on this issue. And number of right has been given to arrest. They can seize of their devices, the mobile and the laptop and all this thing. That police custody, that 15 days time period has been extended to 90 days. This is a major concern, that earlier the law at this time is that after 15 days it has to be judicial custody. Now that time period has been extended from 15 days to 90 days, which can be misused. That political parties is making hue and cry about all this issue, that all these changes, specifically with regard to the special power, has been given to the central agencies also, that they can also do few things which was not earlier there, and now they have trying to added. Wherever there was Delhi Police Establishment Act was there, now they have replaced with the central agencies, all the central agencies, the ED and all this thing. So that concern is there, that police accountability should also be there. There per se there has to be, if police is misusing the power which has been given under this new criminal laws, what is the accountability and what is the punishment for them? So on that aspect, the laws are quite silent, which is one of the major concern has been raised by the people who are opposing or making objection with regard to the implementation of these three laws. And I think that other issue is that 15 days has been increased to 90 days. That is also one of the major concern. And that handcuffing thing, which I already discussed, that also has been raised, ki why economic offense has been not been included, why, what is discrimination, and what is the reasoning, which offense that handcuffing is allowed or for which offense handcuffing is not allowed. So these are one of the concern. Other issue is that few people have also raised objection that there are certain offenses which are per se to be believed civil in nature, that was supposed to be removed from the definitions part or the section. These are still intact and they are still there. And now the another issue which might come into the courts in the coming days once they are implemented, that there might be some conflict with the definition which has been mentioned in various special laws like UPA and the organized crime and all these things. There has been concern that the definition might be overlapping, so which ones to follow, and the punishment might be different in now the Nyaya Sanhita and the specialized law and all these things. There is an issue of overlapping. It has to be seen how the court is going to decide, because these are the issues which are ultimately going to come to the High Court or the Supreme Court to be decided and to be interpreted basically. What is the exact law? And the other major concern was that there are numerous Supreme Court judgments on various aspects, how the bail should be granted, the law should be followed with regard to anticipatory bail or the regular bail, and how the arrest should be made, how Section 41A notice was supposed to be issued. There were guidelines laid down by the Supreme Court. All this has been not been incorporated per se in these new acts, because once the Supreme Court has laid down the law, that was supposed to be, people believe that now we have new criminal law, so they will include all these things, the procedure for anticipatory bail, regular bail, and other issues for which there are guidelines by the Supreme Court. So this is also one of the concern has been raised by people, that all the Supreme Court judgments or the law commissions has also made so many reports. If you remember that adultery, that has to be gender neutral, is also one of the concern, that adultery has to be gender neutral, and that section 377 which has been removed. So now there is no remedy also with regard to if some men want to allege that he has been raped by some other man, or there was some sexual act which is against the natural nature, he can't have any remedies. This has not been added per se.
Sir, what's your like personal view on this? That men still don't have remedy under the law. What do you think
Yes,
about?
I think we have a couple of laws which are not per se gender neutral. The domestic Violence Act, the Dowry Prohibition Act, and the maintenance aspect that came under the 125 of CRPC and all this thing. Numerous times this issue has been raised that the law is supposed to be gender neutral and the men
Mm.
per se are remediless. Now there are some instances where the men has also filed domestic violence cases, maybe against wife, maybe against family members, which has now been entertained. But per se, under the statutory provision, these are not a gender neutral law. Like if you see the maintenance concept under 125 CRPC, it is obviously in favor of wife.
Yeah.
The wife has the first right that once she is abandoned by the husband, that she will claim maintenance as the husband is duty bound to give maintenance. But now these days, even if the wife is earning very well, she is she has a good salary or business or whatsoever, despite that she's claiming maintenance just because she's wife as a female, that she's claiming that under the current law the court has to grant maintenance, court cannot refuse. But there are few instances, few judgments now are coming. I think there is one of the rare judgment, I don't remember the case and from which court it was passed, that the husband was allowed maintenance by the wife, because husband came with all the records and everything that he has no income and the wife is quite earning well and all this thing, so he should be given some sort of maintenance for some very nominal amount or something of that sort. So these were the things which were expected that they might consider, while if you want to say that we are going to evolve a new jurisprudence and we are trying to Indianize this criminal law. Because if you remember, the Chief Justice of India, D.Y. Chandrachud, also have made some passing remarks in some lecture that our present criminal justice system does not reflect per se the Indian society aspect. We have to have our own criminal law system. So that was one of the reasons that they said, okay, now we will consider all this thing. But now the draft and the law is in front of us. Per se, I don't think they have considered all this aspect. There are so many issues. And per se, if you remember, there was no discussion also. Nobody was allowed to participate in the process. Although there was suggestion, recommendation given, we don't know how many of them were actually considered by that committee, which was constituted at that time, which was presided by some academic head at that time. Even the standing committee, I don't know how many suggestions was given to standing committee, which has presented this report in the parliament. And then law commission reports are also not considered. We have hundred of law commission reports with regard to different aspect of criminal justice system, gender neutral, all these things. Everything has not been considered. I think once they are implemented, the government might realize the practical difficulty they might face, which they are not able to foresee currently. So there will be suitable amendments. There is a big possibility that few sections will be declared unconstitutional because of XYZ reasons. Because there has to be some challenge. Because they are on per se quite visible that they need to be challenged and rectified by the court if the government is not willing to do so.
So, what section do you think that should be unconstitutional? I
I think
think
that
that
sedition related,
yeah.
that sedition has been reintroduced in some other terminology with more wider definition, because that
Mm.
judgment is still pending. There is a stay on this 124A, which is currently under the IPC, and now they have reintroduced under some other name, and they have widened the definition. So it has to be challenged. And once the matter is seized by the Supreme Court, logical was that they were not supposed to bring it. And that 377 issue is also there. Let's see, because now they have completely abandoned that section also, that men's has been left remediless. Even for the unnatural sex offense, there will be no remedy. There are so many other issues. Let's see that we might be involved in challenging all this in the Supreme Court or in the High Court.
Yes, sir. Sir, so going forward, how do you see the future with these three laws? Like digitalization is one that we can see that it's really going to impact. And what other things will going to impact the judicial system, the trials
I,
and
yes.
the conviction rate? Will it going to impact the conviction rate in India? And also I want you to discuss something on probation also, any remedy available for accused or for the victims in both ways.
there is no change per se with regard to the probation that I think the current scenario where the way probation are being granted by the state government to some religious leaders, which we can see that every other day these people are out despite they are being convicted for such serious offenses. So there is no per se change with regard to that probation. However, the major impact which I think and I believe that timeline which has been framed to conduct the entire trial, the charge sheet filing time period, the accused when he can be discharged. There's a timeline for that also, and then the judgment has to be pronounced. Although there's the pending cases, I don't think that it will help to reduce the pendency because there is already a huge pendency there. Nothing can be done with regard to that. We have to increase the number of courts because we are not able to stop the filing of the cases because that's not in our hand as and when wherever the civil dispute or the criminal dispute is taking place, people are approaching court. So that number of judges has to be increased. Then only that pendency can be reduced. And another important aspect is there is a timeline that in the trial you are allowed to take only two adjournments, and for which there has to be hearing, there has to be reason given that why the second judgment is allowed, and it has to be recorded in order. But I believe that practically it will be impossible that a trial is conducted in India. Just imagine a murder trial is conducted in India with only two adjournments. There has to be invoked the inherent power or something that whatever reason. But if it is implemented, even to certain extent, let's currently people are taking hundred of adjournment. A trial is going on for 10 years, 15 years. We are in the Supreme Court that we are still challenging the judgment which was passed by trial court in early 90s in 2024 because the High Court was not deciding the appeal. The criminal appeal remained pending for 10, 12 years in High Court, and now it has been challenged in Supreme Court, and now it is pending in Supreme Court for so many years. That two adjournment theory, let's see if it is implemented, that that 100 adjournment if reduced to 50, 40, 30, that is also a welcome step. If there is a restriction under the statute, although there is no consequence per se which has been mentioned, that if the adjournment is taken more than two, what will be the consequence and who has to bear that consequence? Nobody. You have created a restriction, but there is no consequence. So it is a purposeless exercise. But anyway, there is a provision. So let's see. Some judges might to try to get some trial going in a faster mode because every trial is not about 302 and rape cases or some serious offenses. There are trial with regard to some petty offenses also. So for that purpose it is a very welcoming step.
Any changes with summary trials or any other trials, different trials, or this is the only change that
Summary trial is almost same. There is no major amendments with regard to summary trial. I think few new offenses has been added with regard to the summary procedure, that these offenses can now also be tried under the summary offenses, summary trial per se.
but it don't have a retrospective. The if those
There
same
is no
case.
provision per se currently
Hmm.
in the draft, in the act. They are not draft now. These are the act now. So there is no provision per se which says that there will be retrospective effect, because even if they want to mention, it is unconstitutional. Even if they mention, there cannot be retrospective effect with regard to criminal laws. It is quite clear, and the judgments speak for themselves. Supreme Court on numerous occasions has given this, that obviously it is impossible to have retrospective effect. But even if they want to give, there was some statement coming from somebody from the government. I don't know whether to rely on that statement or not. They were saying that the pending trial might be governed under new law. So this is impossible. Let's see if it actually happens. So that need to be challenged.
Yeah. Wow, it's such an amazing session. Really, clear my mind, and I'm sure audience's mind, that how these three laws will going to impact the society. And will sir, one more question: will there be more strictness in for example, in India, people not they're not much afraid of law. So, will there be any change in the
If you
society?
bring provision like community offenses and community punishment, So I don't think people will have any sort of fear that because whatever offenses fall under that category, that there will be only community punishment. You do this and that thing. Now there will be so much laws also need to be evolved with regard to all this thing. But the deterrence aspect for which this law has been changed, we have to see in practical world. Let's see, from I think from next year onward only we will able to see that actually in the society it will make any deterrence per se for which they have been introduced, or the changes have been, the increase has, there has been increase in the punishment for various offenses, specifically for women related offenses. 5 year to 7 has been to made to life imprisonment and all this thing. So there is a possibility that it has to have deterrence effect. But from practical point of view, even if you know the rape offenses, earlier there was no life imprisonment and all this thing, death penalty has also been introduced for gang rape and all this thing. So this has not ultimately affected the offenses of rape. There is no reduction, because when the criminal law was amended, if you remember, with a post Nirbhaya incident, there was major amendment in the criminal laws, and they said ki we will introduce death penalty and life imprisonment for rape. So this has per se the record and the data from the National Bureau of Crime says there is no reduction in those offenses. So let's see if these new criminal law are able to make any difference or deterrence on this society with regard to any of the offenses. But that one of the interesting aspect will be that mob lynching, which was a not a crime per se, not defined earlier, has now been defined. And let's see, even if that has been reduced, because you know the numerous incidented, a particular community used to be targeted because of that cow smuggling and all these thing issues, and there was mob lynching, multiple incidented. Let's see, even if that is reduced to some extent because of this act, so that is a commendable thing.
Great. Thank you so much, sir. Thank you for answering my all questions patiently and really, guiding our audience there. So, uh, anything else you would like to say at the end of the session for our audience, for our lawyer audience, young audience?
I think that now the law has been, president has given her assent ultimately, and now this law will be implemented hopefully by the end of this year. So we should all study first of all what are the changes, because we are as the advocate are responsible now, that under which the FIR will be registered and all this thing, because we have to advise our client also accordingly with regard to all this thing. So everybody should study. The law schools has to introduce all this the new laws in their curriculum, and they have to replace the earlier laws. And I also believe that we, in case of some difficulty while implementing all this thing, and we believe that something is wrong and something is per se is not as per the standard or the rules laid down by the court, advocates should be vocal about all this thing, and they should raise this issue, and they should file appropriate writs before the high court or supreme court, wherever, to raise that this per se provision like sedition and all this thing is unconstitutional, should not be implemented. So from that perspective, lawyers have to work hard. And I think with regard to litigation, immediately after implementation there will be increase, because there will be confusion what to do, what not to do. The law will evolve. Like if hypothetically these laws are implemented in December 2024 of this year, so the law will start evolving from next year onwards. The judgment will start coming from 2025 onwards, from district court, high court, or supreme court, whatsoever, for whatever reasons. And then only we will have clarity with regard to, there are obviously, there are, whenever there are new law, there are manner the which it will be interpreted by the court or by the client or by us is different. So that clarity will be required. So 1 or 2 or 3 year, I think it will easily take to understand what the provision actually mean and how the court has interpreted to settle the law on that issue. So all these things will be there. There will be increase in litigation. I believe that pendency aspect is not going to ultimately to see the light of the day, that the pendency has been reduced because of these implementation of new laws. I don't think it will impact any pendency. The pendency is going to increase, and it will take few years at least to settle down. and have clarity about all this law. And I also believe that there will be suitable amendments in the coming days with regard to various provisions, as and when the inconsistencies in these provisions are made public or challenged in the court. So let's see.
One more question I just feel to ask that will the procedure that is defined in the CRPC for proclaimed offenders, will it also go complete digital?
Yes, yes, yes.
Oh,
It is also
okay.
falling under that category, and there is the digitalization of that procedure which need to be followed with regard to the proclaimed offender. And there are certain amendments with regard to there is a timeline also that in which time period that person has to be declared the proclaimed offender, and how this person should be informed about all this order, so that summoning and all the warrant which are issued and all this thing is about to take place. That timeline has been framed, so that will also impact, because that digitalization thing and that all this thing will be done through electronic means is applicable usually on all these cases.
Yeah. Great. Great. Thank you so much, sir. Thank you so much for solving our queries, our questions, guiding us through this new laws. Thank you for the session. Let's just say bye to our audience. We don't have any question in the comment sections. We just have hi for you. We just have namaste for you, and no no any other questions. And people are saying thank you to you for this session. So yeah, and I'm also
Thank you,
thankful to you for
everyone.
this session.
Thank you, Hina, and thank you, LawSikho, again. I think this is a we have another wonderful discussion, because this is
Thank you.
something which was required to be discussed, so the
Yes.
general public will also understand. Thank you for inviting me again, and thank you to everyone.
Thank you everyone for joining us. And if you want to follow our guest speaker, you want to get in touch with him, you can search on LinkedIn, Mr. Webhav Chaudhary. You can find him on LinkedIn. And also, if you want to connect with me, you can search on LinkedIn, Advocate Hina Joshi. So thank you very much. Thank you.
Thank you, Hina. Good day.
Thank
Thank
you.
you,
Sir.
everyone.
Thank you.